Hello, today I'm with Ian Rowson, partner in the property department at Freeth, Cartwright. Ian is a keen golf-playing member of Holywell Golf Course in the heart of Sherwood Forest. Hello Ian.
Hello Robert.
Ian's going to talk to us about rights of light and how they arise.
Indeed, a right of light is an easement like any other easement, and to that extent it is actionable by a claim by a third party claiming a nuisance or infringement of its right. Rights of light are not normally granted by express grant. They normally arise by a long user under the Prescription Act 1832.
Now, the law is long established. Have there been changes recently?
There have indeed been recent changes. There's been two cases in particular, Reagan against Paul Properties, and more importantly, a case I'll refer to as the Heaney case. The Heaney case is particularly important, and it's important because prior to the Heaney case, people had thought that if a party delayed in bringing forward its property rights before development had commenced or been completed, that the award to the infringed party's rights would be of damages, not of a mandatory injunction. What happened in the Heaney case is the court decided that the infringed party's rights were such that they were entitled to a mandatory injunction even though the development had been completed and the rights hadn't been enforced during the development period. Additionally, it had previously been thought that where the circumstances were such that the developer's rights would be significantly infringed or the damage would be disproportionate compared to the infringement to the third party, that again there would be a claim standing in damages, not a mandatory injunction. The Heaney case changed all that, and developers now have to face the uncertainty of a mandatory injunction being brought even after a development's been completed.
So, what practical approaches can be taken? Is it insurable?
I'm afraid insurance post-Heaney is very difficult to achieve. It's also difficult in practice to satisfactorily negotiate deeds of release with the various parties who may have the benefit of the rights. But one practical approach that can be taken, particularly in the context of town centre development, where a local authority is involved, is to persuade a local authority to utilise its positive planning powers under Section 237 of the Town and Country Planning Act 1990. And what in effect that means is that if a local authority appropriates land for planning purposes, it has the effect of overriding the third party rights and interests subject to payment of compensation, but critically the compensation is payable on the basis of Compensation Act principles and not by virtue of ransoms. And a practical example of this occurring in practice is the walkie-talkie tower that was constructed at 20 Fenchurch Street by Land Securities, which is explained in more detail in my briefing note.
And it's a very comprehensive briefing note with this video. Thank you very much, Ian, for your contribution. Ian Rowson, thank you.
Thank you, Robert.